All rise.
Yes, Mr. Crowe.
May it please you, my lords, we were going to address you under four broad headings. First, the interpretation of section 65. Secondly, external factors, that is, external to the section, which support our interpretation. Thirdly, relevant authority on that particular point, insofar as there is any. And fourthly, whether there are any considerations which should drive the court to a different conclusion. Starting then with the first heading, the interpretation of section 65 itself, the parties are agreed that the word tribunal in 65(2)(a) is capable of referring to courts. The question is whether it does in this case. And if I could just very briefly take you through the wording and make some short observations on the section as I go through. It's page 260 of the core bundle. And you'll be fairly well familiar with it already, but I just want to pick up a few features of the case. Subsection 2, the jurisdiction of the tribunal shall be to be the only appropriate tribunal. Obviously, the word only must be given force. In our submission, it supports the approach that this is intended to be a provision which provides for exclusive jurisdiction and not one that leaves litigants with any choice. As a matter just of parliamentary history, we mention in our case at paragraph 58 that the word only appeared by way of amendment during the course of the bill's progress. It was not, however, debated, and it wasn't really explained in any real detail. We checked Hansard and didn't consider that anything there assists you with the issue that you have to decide. There was a very brief commentary provided when the amendment came forward, and we can provide that if it will assist you, but the words it uses don't, I think, take the debate very much further forward. The effect was described as being to clarify that the tribunal established by this bill should be the only appropriate tribunal for the purposes of section 7(1)(a) of the Human Rights Act. Rather than explaining, I think it actually just parrots the wording of the section.
Was this in the House of Lords or the House of Commons, do you
know? Commons, my lord.
So it was, previously it said to be the appropriate tribunal.
Yes. But in any event, so the introduction of the word was clearly deliberate for emphasis, and we would suggest that it was the emphasis that it was intended to carry was an emphasis on exclusivity. That doesn't necessarily take one all the way, because obviously the point remains, is it exclusive of other tribunals or exclusive of courts? But that one gets with the next word that I wanted to emphasise.
Well, you get it by yourself, don't you? Because in order for any court or tribunal to have jurisdiction, it has to be assigned.
Yes.
And so if you said the appropriate tribunal, it would still be the only one. Yes, so it only must have been intended to add something else.
Emphasis, one would think.
Well, possibly to deal with the fact that no court proceedings.
Exactly. I'm obliged. And that is reinforced if one carries on with paragraph A to be the only appropriate tribunal for the purposes of section 7 of the Human Rights Act 1998 in relation to any proceedings under subsection 1A. And the word any in our submission is critical because it clearly means that 65(2)(a) does not confer jurisdiction on the IPT only in relation to proceedings that might otherwise have been commenced in some other tribunal, and it doesn't confer jurisdiction only in relation to proceedings relating to the exercise of powers that are regulated under RIPA. It confers jurisdiction in relation to any proceedings under 7(1)(a) of the Human Rights Act. And in our submission, the combination of those two words, only and any, produce the result that the tribunal plainly is the only, to use another word, forum, the only judicial body that is capable of hearing proceedings under Section 7(1)(a) of the Human Rights Act.
Of course, the word any has to be linked to what follows, which is the reference to subsection 3. So it's not any proceedings, actually,
No.
is it? It's any proceedings of the kind referred to in subsection
Absolutely.
3.
And I was going to take you to subsection 3 right now as our next point.
Just before you do, what is the touchstone as to whether it is proceedings brought under? A person who claims, in a way which is made, who claims that a public, I'm looking now at Human Rights Act, Section 7. A person who claims that a public authority has acted in a way which is made unlawful
Yes.
by Section 6(1) may bring proceedings against the authority under this Act.
Yes.
Now, why do we say that the claim that we're dealing with falls within that? Why is it brought under this Act when there's no reference to the Act, no reference to Section 6(1), and it's in precisely the same terms that it could have been in before the Act came into existence?
Lord, this was a point that was debated at first instance and not in the Court of Appeal. Mr. Justice Collins dealt with it at paragraph 20 of his judgment, and it hasn't been reopened since. And so we haven't got developed arguments in relation to that. But the
What does he say?
the claim form itself, which you will find at page 3 of the appendix, well, you'll find it starting at page 1. In a sense, the formal answer to your question is the first box on page 3. Does the claim include any issues arising from the Human Rights Act? Yes. If yes, state the articles. Article 10, freedom of expression. So the formal answer to your Lordship's question.
Right. I haven't found this.
I can't find it.
I'm sorry, page 3 of the appendix.
Oh, I see.
At the very, very
yes,
top, the
yes.
first box. Does the claim include any issues arising from the Human Rights Act 98? Yes. If yes, state the articles. Article 10, freedom of expression. So the answer is that the pleaded case against us is Article 10. So that is why we apprehend that although the claimant also added a bias and an irrationality argument, and there was some debate at first instance as to whether the addition of those general public law claims took it outside Section 7(1)(a, Mr. Justice Collins decided that they did not take it outside Section 7(1)(a, and that point was not renewed in the Court of Appeal, and no application to renew the point has been made before you.
Well, I mean, just assume the claim form had said no, and it had simply gone on irrationality. I mean, could the claimant have then deployed the full force of Article 10 in support of an irrationality challenge?
Could I reserve our answer to that and come back to it? Because it's one of the things that we find do help in this case is to focus on this case and what has happened rather than on some hypotheticals. But
It's not very satisfactory if the tribunal depends on the form and not the substance of the claim.
Lord, I think that was in part, I would wish to refresh my memory of what Mr. Justice Collins said, but I think that was in part what underlay his reasoning.
In some of
Sorry, I was going to say, if you look at paragraph 20 on page 27, it is quite helpful, although I confess he's referring to what I said. But the point is that if you make a claim under Section 7(1)(a, your court or you're bringing yourself within a regime which has a time limit.
Yes.
And you're also invoking remedies which are provided for in the Act. So
yes.
you need to know where you stand. I mean, obviously, you have a time limit for judicial review in itself, but you have a time limit that applies to claims under the Act. And the remedies are quite broadly expressed in paragraph 8, or section 8 of the Act. So I think, for myself, if the purpose of the form is to identify whether you are invoking that that type of claim, and if you are, then you take the consequences and the benefits.
Yes. I mean, if the complaint had merely been bias, then that would, I apprehend, simply be a public law claim. If the claim had been pure irrationality, then that would be a public law claim. But if in fact what the claimant was trying to do was to bring a complaint based on Article 10, dressing it in the clothing of an irrationality challenge, but trying to benefit from the test of proportionality and the right to freedom of speech under Article 10, then in substance it would presumably be regarded as a claim under Section 7(1)(a), although it was dressed in the clothing of something else.
Yeah, I think, if I can quote myself, I think that was what I was trying to say in Somerville in paragraphs 172 to 175, which I think Lord Scott agreed and Lord Brown had some sympathy.
Yes.
Can you give the paragraph again?
172 to 175. In other words,
it's Somerville and the Scottish ministers, which Mr. Justice Collins also quotes at paragraphs 22 and 23.
Unfortunately, his quote is garbled.
Yes, it doesn't
places.
do full justice to the original one, Lord.
I did check that at least I think, unfortunately.
But I think my Lord Phillips' question must be answered as a matter of substance rather than as a matter of form.
Yes.
I mean, I remember in days past one used to sort of litigate cases like One Woman's War comes to mind. I think I sat at first instance. And that was a publication by some woman from the Security Service about what she was doing 50 years before the service. Now, what sort of basis was one litigating those cases? I mean, did Article 10 ever come in the picture? I can't remember that it did.
Nor can I.
But I mean, it's not, there's nothing very novel about stopping ex-officers of the Security Service from writing books.
Lord.
I'd be quite interested to know how it all used to work. I can't remember.
Lord, I would have to remind myself of that too,
Yeah.
but I'm immediately reminded that the case of Brind was an illustration. Was an illustration of the decision that you could not rely on convention rights before incorporation.
Yes.
So the answer to your question, is only a partial and rather unhelpful answer, but the answer is presumably not. That those cases were being argued indirectly by reference to Article 10, which they shouldn't have been.
I mean, the supposition we all were making yesterday, I'm not at all sure it was right, namely that, so to speak, all these convention rights were simply there as part of the common law anyway. I'm not sure they were.
No, indeed not. Indeed not. And as I say, Brind it was before the Human Rights Act came in.
All Brind said was, though, that you couldn't rely upon a provision of an international convention unless it had been incorporated into English municipal law,
which was the state
isn't quite the same point, is it?
Well,
because it might have reference to the convention, might have other relevance in the development of the common law. So,
but all you would be doing would be arguing for common law. You would not be invoking Article 10 of the Convention per se. So,
would you not, if you're interpreting a statute, I thought the theory was that Parliament was assumed to have legislated in accordance with international obligations, and therefore you could.
But that wouldn't be the point that would arise. There wouldn't be a statutory cause of action available to an ex-MI5 officer entitling them to publish in breach of their contractual obligations to the service.
So there's a common law principle, isn't there, that the public authority should not be entitled contractually to fetter or to restrain publication of a matter that's in the public interest.
My Lord, there is a general principle that confidentiality is a qualified privilege, and that in the private law sphere, a breach of confidence depends on confidential information disclosed in circumstances of confidence and a disclosure in breach. The Crossman Diaries case shows that there's a fourth element if government wishes to bring a breach of confidence claim, which is that the publication would not only be a breach of confidence, but that it would be damaging to the public interest. Lords, I was going
What would be the position of, suppose A had simply published and or threatened to publish, and he was defending injunction proceedings, what would be the position then under these provisions?
Under RIPA?
Yeah. Well, and the Act.
I'm sorry?
Under RIPA, yes.
Yes.
This is one of Mr. Miller's points.
Yes. Can I get to that, my Lord? Because I've got quite a lot to get through in answer, and I would like to take the points in sequence. And I'd like to start just by getting the points on interpretation lined up first. We looked at 6.2a. We were going to go on to subsection 3. As my Lord Hope pointed out a moment ago, what 6.2a deals with is the allocation of jurisdiction in relation to any proceedings which fall within subsection 3 of this section. Subsection 3 covers under 3a proceedings fall within this subsection if they are proceedings against any of the intelligence services. So again, the language is entirely general. It's proceedings against the intelligence services. It's not proceedings that might otherwise have been brought in a tribunal against the intelligence services, and it's not proceedings relating only to the exercise of the powers of surveillance and investigation, which are regulated.
Agrees you couldn't get to that except by section 3.
I'm sorry, my Lord?
I think everybody agrees you couldn't get to this third meaning except via section 3.
Yeah. My Lord, in our submission, it is clear from the general wording of 3a that what 6.2a is allocating is jurisdiction to the exclusion of courts and tribunals, because it simply refers neutrally to proceedings, not to proceedings that might otherwise have been brought in a tribunal. The reason why, I mean, obviously some emphasis has been given by the other side to the use of the word tribunal in 6.2a rather than court or tribunal, and our answer is exactly the same as Lord Justice Law's, which is that it is entirely natural to use that particular phrasing, and indeed it would have been clumsy and, in a sense, inaccurate to have said court or tribunal when you are referring to and allocating jurisdiction to something which is just a tribunal. And so that is at least one explanation of the use of the word. It is simply accuracy and elegance. The other point to be made about the use of the word tribunal rather than court or tribunal in 6.2a is the point my Lord Mance made yesterday by reference to section 7.2 of the Human Rights Act, which is to be found at page 146. Your Lordship will probably remember the point, and it is very short, but in our submission entirely compelling, which is that subsection 2 of section 7 at the top of page 146 provides that in subsection 1a, the phrase appropriate court or tribunal means such court or tribunal as may be determined in accordance with rules. So the effect of that is that where a provision such as section 65.2a identifies a tribunal for the purposes of section 7, section 7.2 means that that tribunal is the appropriate court or tribunal for the purposes of section 7.1a. And in our submission, there isn't an answer to that. It is the correct interpretation of section 7.2, and it is the explanation for why the word tribunal rather than court or tribunal is used in section 65.2a. The other point that was floated against us is that in 65.2b, one sees the word forum, and it was suggested, well, forum is a neutral term, it can cover courts or tribunals. In our submission, 65.2b is dealing with something entirely different. It is dealing with complaints, that is, things that are not legal proceedings. 65.2b is, in a sense, the successor. You will remember that under the 1989 Security Service Act and the 1994 Intelligence Services Act, there were tribunals set up to deal with complaints. Long before the Human Rights Act came along, there were tribunals to deal with complaints, and 65.2b effectively confers on this IPT, as successor to those tribunals, that bit of jurisdiction. But it is a jurisdiction to deal with complaints, which are not legal proceedings, and therefore a completely different word is used, forum, which is not a word in Section 7 of the Human Rights Act at all, because what section 65(2)b is dealing with isn't legal proceedings. It's complaints which get investigated, not claims that get tried. And so that is the explanation for the use of the word forum. It tells us nothing about the scope of 65(2)a. So for those very short points, we say our interpretation of section 65 is plainly the right one, as was correctly held by the majority in the Court of Appeal. And one isn't taken away from that, for instance, by section 66. Some reference to that was also made. You'll remember section 66 is the sister section to section 65(2)d. 65(2)d provides a sort of a residual category of jurisdiction for the IPT, which allows it to hear and determine other proceedings as may be allocated to them in accordance with provision made by the Secretary of State. And in that context, section 66 provides that an order made under 65(2)d may provide for the tribunal to exercise jurisdiction in relation to that matter to the exclusion of the jurisdiction of any court or tribunal. And so a point is made against us. Well, there you have in 66, 1a, express reference to court or tribunal. Contrast that with 65(2)a, it is said, and the use of the word tribunal only in 65(2)a suggests that the jurisdiction must be exclusive to the jurisdiction only of tribunals, not of other courts. Our answer to that is very short, which is simply that 65(2)a does what it does in the way that it does for the reasons we've already given. It's referring to something that is a tribunal, and because of the way section 7(2) of the Human Rights Act works, it means court or tribunal. But where one is dealing in section 66, 1a, with an entirely prospective provision, which is clothing the Secretary of State with a power to make rules in the future, orders in the future, simply as a matter of clarity, it was entirely natural for the draftsman to say to the exclusion of the jurisdiction of any court or tribunal, because the Secretary of State might wish to make an order that does one or the other, but not necessarily both.
Well, they're different things. I mean, in 66(6)(1) is talking about excluding.
Yes.
And you've got to look at both of them, whereas 65 is allocating.
Exactly.
Or identifying. And you identify the tribunal.
Yes.
That makes sense there. But if you're excluding, then you've got the power to exclude courts and tribunals, because that covers the entirety of the range within which these things might be considered.
Lord, I
think it's different exercises, yes. Really, is the explanation there.
I'm grateful. That is I'm grateful. I would wish to adopt that, and I think that's a clearer way of putting the point. Could I just draw your attention?
D not yet in force? 65?
No, it's not. Could I then just draw your attention to a couple of other matters in the Act itself, which support our interpretation, and just to draw any venom that may remain in the points that have sought to be made against us.
I mean, it seems rather odd that D is not in force, because it wouldn't take effect unless and until the Secretary of State decided to make an order.
Yes.
So it seems a bit bizarre that one shouldn't bring it into effect and clothe the Secretary of State with that power.
Yes.
and that, I mean, in a way, that would produce a scheme which would seem, at the moment to me, to be more satisfactory than a scheme which said that everything's got to go to the tribunal, and the tribunal hasn't got a power to say this really isn't suitable for us.
But, Lord, that is a comment, if anything, on the policy of the department in whether or not to bring that section into force. What we're arguing before you is a pure question of statutory interpretation, and the interpretation of 65(2)a can't be influenced by a policy choice of the incumbent administration whether or not to bring 65(2)d into force at any given moment.
As I understand D, it doesn't give a power to take away anything from A.
No.
I mean, that's quite important.
It's an
Parliament's made its decision about
exactly.
A and also 3A, subsection 3A. So it's, I suppose, catering for the possibility that something else might turn up sometime.
That, of course, all depends on the scope of A.
Lord, yes, absolutely. absolutely. But I've addressed it on that.
The present position is pretty anomalous, pending D being brought into force on any view, isn't it? We've heard submissions that this is relevant to A, but quite apart from however wide A is, it's simply anomalous. Just take a claim under section 55(4), that is for misuse of a key.
Can I deal with anomalies later? Because I do want to develop the argument in order. I will come to the anomalies under my fourth heading, and I don't particularly. I prefer not to take them out of sequence. I'd be grateful. What I was just going to do to wrap up the Act is just to go to a couple of other provisions which have been discussed. The first is just the long title, which was invoked. That's page 155. And you'll see it's quite a long title. An Act making provision about interception and so on. And then in the fourth line, you see, to provide for commissioners and a tribunal with functions and jurisdiction in relation to those matters, that is, all the interception matters and surveillance techniques, to entries on and interferences with property or with wireless telegraphy, and to the carrying out of their functions by the Security Service, the Secret Intelligence Service, and the Government Communications Headquarters, and for connected purposes. So there was an attempt, I think, by my learned friend, Mr. Miller, to rely on the long title in support of his third interpretation, to say, well, the tribunal was really only set up to deal with complaints about the exercise of the surveillance and investigatory powers that are regulated by the Act. But the long title gives the lie to that, because it relates not only to those, but it's a jurisdiction in relation to those matters and to the carrying out of their functions by the Security Service, SIS and GCHQ, and for connected purposes. So one cannot derive from the long title any suggestion that the jurisdiction of the IPT was intended to be confined to dealing with complaints about the exercise of the various investigatory functions which are regulated by RIPA. And just as something of a footnote to that, you will see that the long title refers to the carrying out of their functions by the Security Service. It was also suggested by my learned friend Mr. Miller that doesn't include, or doesn't principally include, the kind of decision that is being impugned in this case. And I just wanted to take issue with that and remind you of exactly how the service's functions are described, which is page 120 in the appendix. Page 120 has the other two services have comparable provisions, but we'll just use the Security Service as the illustrator.
Which section are we looking at?
We're looking at section 2. We've looked. Your lordships have taken to section 1, which provides at subsection 2 the protection of national security against threats from espionage and so on. And then section 2, subsection 2, provides that the Director General shall be responsible for the efficiency of the service, and it'll be his duty to ensure that there are arrangements for securing that no information is obtained by the service except so far as necessary for the proper discharge of its functions or disclosed by it except so far as necessary for that purpose or for the purpose of preventing or detecting serious crime. Now, the reason I draw that to your attention is simply this, that it is the very essence of the Security Service that the discharge of its functions necessarily involve acquiring information. That is why 22A has such a prominent position. No information is obtained by the service except so far as necessary for the proper discharge of its functions. But it is also an absolutely critical, an as critical element of the service's functions that it should not disclose information other than except insofar as necessary for that purpose or for the purpose of preventing or detecting serious crime. So the Act expressly requires arrangements to be made for the acquisition of information to be confined to the statutory functions and also for disclosure to be confined to those statutory functions. And that is critically important because otherwise, obviously, the regime would not work. It would not be a security service. And so what is being done in this case is absolutely central to that function, because what is happening in this case is a former officer of the security service wants to make disclosures. And the decision that is being impugned is a decision by the security service not to agree to that. So it is quintessentially an exercise by the service of one of its principal functions, which is ensuring that the intelligence it obtains is not disclosed, except so far as necessary for the purpose of its statutory function. So feeding that back into the long title to RIPA, you have a tribunal with jurisdiction in relation to the carrying out of the functions of the security service. That is precisely what this challenge is about.
It's my fault. I didn't pick up the page you were reading from.
I'm so sorry. It's the 1989 Security
Yes.
Service Act is page 120.
120, thank you.
And it's section 22A. Going back to RIPA, the other point that was made passingly against us was the heading to Part 4 of RIPA, which is to be found on page 249. And again, we would just make the same point about that. Part 4 is subheaded Scrutiny, etc., of investigatory powers and of the functions of the intelligence services. You'll see at the top of 249, Part 4, Scrutiny, etc., of investigatory powers and of the functions of the intelligence services. So again, my learned friend Mr. Miller cannot derive any support from the heading to Part 4 for his third interpretation. And so our submission there is that both the long title and that heading entirely support the Court of Appeal, the majority in the Court of Appeal's interpretation, and the interpretation we would urge on you. Next indicator in support of that interpretation is the explanatory notes. I apologise for some reason, certainly in my copy.
Sorry to interrupt. I'm terrible. I mean, just going back to 155, I mean, the functions in line 5 are the Commissioner's functions, not the Security Services functions. And the Commissioner has...
So which page, Will?
To provide, in the fourth line, to provide for commissioners and a tribunal with functions and jurisdiction. So functions is commissioner, tribunal is jurisdiction.
That's right.
So reading what we would urge are the relevant words, it's to provide for a tribunal with jurisdiction in relation to those matters, to entries on and interferences with property or with wireless telegraphy, and to the carrying out of their functions by the security service.
I see, you're referring, to the functions in the third line from the bottom.
Sorry, I read it too fast. I apologise.
And is that all qualified or introduced by the words in relation to, as regards the tribunal?
That is how we would invite your lordship to read it. And it is only a heading, a long title, so I don't want to spend too long unpicking it, but that would appear to be the natural reading. It's a tribunal with functions in relation to, ... Sorry, with jurisdiction.
Yes.
In relation to ... the carrying out of their functions by the security service and the other two.
Well, actually, the 2 is repeated, so it's quite clear, isn't it?
Yes.
Oh, yes.
Yes, I'm grateful. The next indicator that supports our approach is the explanatory notes to RIPA. They are, or at least bits of them, are in the authorities bundle, but I think the wrong bits, and I apologise for that. The only thing you actually need is paragraph 320 of the explanatory notes, but I think it's certainly not in my bundle, but we handed up two things which I hope are on your desk. One is the Hanlon case that my Lord Panic referred to yesterday, and the other is the right bits of the explanatory notes. And what we've done is simply copy the explanatory notes to part 4, and if you go to the third page of that print-off, you will see paragraph 320 of the explanatory notes, subsections describing section 65, it says subsections 2 to 8 set out the key elements of the tribunal's jurisdiction. It is to be the appropriate forum. It uses that word. It is explanatory notes, it's not legislation, so it's a little less precise, but it is instructive that it uses the word the appropriate forum for complaints or proceedings in relation to the following categories. First bullet point, any proceedings for actions incompatible with convention rights, which are proceedings against any of the intelligence services or people acting on their behalf, and then it goes, and so on. And so in our submission, this being the non-legislative language that is used to describe the effect of the legislation, the use of the word forum here is entirely understandable, and it is entirely consistent with the majority in the Court of Appeal and with our submission. My Lord, I don't think there's any dispute. Your Lordships, I'm sure, are familiar with the principle that explanatory notes are an admissible aid to interpretation, and we didn't cite any authority in support of that. I don't think it's in dispute. But it's the case of our Westminster City Council against the National Asylum Service, if your Lordships wanted assurance on that point. The next point, just on interpretation, Hansard has been quoted extensively in my learned friend's case. In our submission, he didn't take you to it in his oral submissions rightly, because none of the passages actually satisfy the test in Pepper and Hart. Nothing that was actually said during the passage of this section through Parliament deals with the specific question with which you are concerned, and so Hansard doesn't assist you, which leaves one in our submission with the position that the plain language of 65(2)(a) is correctly interpreted by the Court of Appeal. That interpretation is plainly supported by the explanatory notes and by the long title and the heading to Part 4. In response to that, my learned friend Mr. Miller puts forward three interpretations, the first of which, applying George Carman's exhortation, he's abandoned. The second of which is the one that says what Lord Justice Ricks and Mr. Justice Collins said, which is that the exclusion only operates to the exclusion of tribunals rather than courts. For the reasons we've given, we simply submit that that is wrong. We would also simply add that in our submission it would be pointless if that were 65(2)(a)'s function, because it does not appear that any other tribunal would have had any jurisdiction to determine a claim under Section 7(1)(a), but for Section 65(2)(a). So making express provision in that regard would have been unnecessary. The only footnote I would add to that is that we should, in our case, and I apologise that we didn't, we should have picked up the error in Lord Justice Ricks's judgment, which my Lord Brown pointed out yesterday, where Lord Justice, I don't ask you to go to it, but you may recall that at paragraph 33, Lord Justice Ricks recited that it's common ground that there is another tribunal, which, but for Section 65(2)(a), claim that a public authority has acted in a way unlawful under Section 6(1) might have been brought by way of Section 7 proceedings. It was not common ground, and it is not the case that there is any other such tribunal.
And that's the employment tribunal.
Yeah.
But I mean, all three of the members of the court made that mistake.
Yeah, they did. And I'm sorry, we should have corrected it in our case. So, Lords, that is all we wished to say about the second interpretation. The third interpretation my learned friend advanced was the idea that the effect of 65(2)(a) is to exclude the jurisdiction of other tribunals and courts, but only in relation to claims brought in relation to the exercise of the investigative and surveillance functions which are regulated by RIPA. We submit that that is plainly wrong for the various reasons we have explored, but there is also one slightly more detailed reason why it's wrong. And I just wanted to take you back to Section 65 to show you that. It's, if we could go back to page 260. We've already seen that 65(2)(a) confers the jurisdiction in relation to any proceedings which fall within subsection 3, and we've seen that subsection 3a covers any proceedings against the intelligence services. If we just contrast 3A with 3D, we see that proceedings fall within this subsection if D. They are proceedings relating to the taking place in any challengeable circumstances of any conduct falling within subsection 5. Now, as you may recall, conduct falls within subsection 5 if, among other things, it is conduct by on behalf of any of the intelligence services. That's 5A. And you may also recall that challengeable circumstances is a term of art, which is defined in section 65(7), and it's a bit painful getting through it, but essentially what subsections 7 and 8 provide is that what challengeable circumstances mean is circumstances covered by actions which are regulated by RIPA, or which should have been authorised pursuant to RIPA, but perhaps weren't. So what one gets from that, it's a little bit dense, but what one gets from it is that the jurisdiction which is being referred to in 65(3)(d) is specifically jurisdiction to deal with complaints about the operation of investigative surveillance functions which are regulated by RIPA. Now, if section 65(2)(a) was itself only confined to the determination of complaints about the exercise of the functions which are regulated by RIPA, then in section 65(3), paragraph A would have been wholly unnecessary, because D would achieve what my learned friend suggests that 65(2)(a) was intended to do. D covers specifically complaints about actions taking place in challengeable circumstances. That is exactly what he says 65(2)(a) is confined to. If he were right, 65(3)(a) simply wouldn't be there. 65(3)(a) must have been intended to be broader than 65(3)(d), otherwise they wouldn't both be there. And in our submission, that demonstrates that the third interpretation must necessarily be wrong.
Can I ask you the other way around? If A is broader than D, what is D there for? Well,
D is there to catch. To be honest, I don't wish to be impertinent.
I mean, why is D necessary?
Perhaps a more difficult question is actually why 5A is there. Because you've already got 3A, proceedings against any of the intelligence services. 3D captures proceedings relating to the taking place in challenging circumstances of any conduct. In 5 could perhaps more logically have started with B, because you don't need to repeat the intelligence services. But what D, 3D and 5 catch is conduct other than by the intelligence services. It happens also repetitively to include investigative functions by the intelligence services, but it does that perhaps unnecessarily by including 5A. But what it also does is to capture other investigative functions, complaints about other investigative functions by bodies other than the intelligence services, such as the police and so on. Lord, the same point...
yes, I see. Yes.
So, Lord, in our submission, that does demonstrate. It's a slightly painful process to get there, but once one does get there, one sees that the extent of the IPT jurisdiction would in fact be defined, if my learned friend was right, entirely by 65(3)(d), and there wouldn't need to be A. Now, my learned friend, again, following Mr. Carmen's exhortation, came up with his fourth argument, which was the one that if he's wrong on his second argument, and he's wrong on his third argument, and the jurisdiction is not confined to complaints about the exercise of investigative functions, he says, as a fallback argument, this is paragraph 10 of the summary he handed up yesterday, he says, as a fallback, Section 3 of the Human Rights Act requires an exception to be read into section 65(2)A in relation to Article 10 cases. Now, so far as that is concerned, I just wanted to make some short submissions, because I'll deal with the ECHR in a little more detail later, but I just wanted to make three very short submissions. The first point is simply that the whole argument, this fallback argument, is predicated on Section 3 of the Human Rights Act, and so it is entirely parasitic on the ECHR arguments, which, as I say, I'll deal with in a moment. The second point we would make about this fallback is that in our submission, what is proposed would involve judicial rewriting of Section 65(2)A in order to achieve, in this context, exactly what the section was drafted to avoid, namely a Human Rights Act claim against the services proceeding in the ordinary courts. That's precisely what 65(2)A is intended to avoid, and using the language of Lord Roger in Gaidan and Godin Mendoza, that, in our submission, goes against the grain of the legislation, or to use another colourful expression of Lord Bingham, it involves judicial vandalism, which comes from Anderson and the Secretary of State. In our submission, it is not a permissible exercise of the Section 3 interpretative power. It would, in particular, be directly inconsistent with the application of Section 65(2)A to any proceedings under Section 7(1)A, and it would also result, we would submit, in Article 10 cases being carved out when they are, in fact, squarely within exactly what the IPT was intended to deal with. For example, if a person wanted to publish allegations that the service was conducting interceptions without the proper RIPA authorisations, he would invoke Article 10. An inquiry into whether or not the appropriate RIPA authorisations had been made is exactly the kind of issue that the IPT was intended to deal with. The third point that we would make about this fallback argument is that carving Article 10 cases out of the IPT's jurisdiction would turn its jurisdiction into something of a lottery. Because if one imagines a case of a journalist, for example, complaining that he was subject to improper surveillance, and that can constitute an interference with his right to private life under Article 8, he'd have to go in the IPT. But if he reformulated exactly the same complaint and said it had a chilling effect on his right to freedom of speech because it was interfering with his work as a journalist, and it was therefore a complaint under Article 10, if you have carved Article 10 out of 65(2)A, as my learned friend would wish, then he could pursue that complaint in the ordinary courts. So, as I say, my learned friend's interpretation is both inconsistent plainly with the grain of 65(2)A, and it would produce a result which would effectively, as I say, be a lottery. So for those reasons, we submit that, just wrapping up that for our first heading, as a matter of interpretation, in our submission, 65(2)A plainly has the meaning that the Court of Appeal arrived at, the majority in the Court of Appeal arrived at. The second heading I wanted to address you on is external indicators which support the Court of Appeal's approach, these consist of two elements. The first is simply a number of related pieces of legislation which show that where Section 7(1)A jurisdiction is being allocated, the word tribunal is habitually used by Parliament to mean court or tribunal. No doubt for the Section 7(2) reason that my Lord Mance put yesterday. And we just have a couple of illustrations of that in Authorities Bundle 10. Bundle 10 at tab 96, we have the Extradition Act 2003. And if you'd be good enough to start at at section 195, which is on the second sheet, and you'll see at the foot of the page, under the heading Human Rights, Section 195, human rights, appropriate tribunal. The appropriate judge is the only appropriate tribunal in relation to proceedings under Section 71A of the Human Rights Act, proceedings for acts incompatible with the Convention rights, if the proceedings relate to extradition under Part 1 or Part 2. If the proceedings relate to extradition under Part 1, Section 67 tells you who the appropriate judge is, and under subsection 3, if the proceedings are under Part 2, Section 139 tells you who the appropriate judge is. And we also have those, you see it's district judge in England and Wales, the sheriff in Scotland, and the county court judge in Northern Ireland. What that demonstrates is that what matters is the wording of 195, subsection 1. The appropriate tribunal, the only appropriate tribunal, is a word used to describe a tribunal which is in fact a court in the ordinary sense. So it simply supports, as a matter of related statutory usage, the interpretation of tribunal in 65(2)A as meaning court or tribunal. And we get the same thing at tab 98 in the Prevention of Terrorism Act 2005, section 11. Control order decisions and derogation matters are not to be questioned in any legal proceedings other than proceedings in the court or proceedings on appeal from such proceedings to the court is the appropriate tribunal for the purposes of Section 7 of the Human Rights Act 1998, and in this context, the court is a phrase defined in Section 15 over the page. You'll see at the top of the facing page, the court, in relation to Scotland is the outer house of the Court of Session, Northern Ireland is the High Court, and England and Wales is the High Court. So again, one has the usage there of tribunal as the label for describing the judicial body in front of which Section 71A proceedings are brought, and it is a word that captures court in the orthodox sense. One also has, just for interest, at tab 99, the POAC rules, Prescribed Organisations Appeal Commission rules, and there one sees, in fact, the word tribunal being used to describe the Commission itself. POAC, established by Section 5 of the Terrorism Act, is the appropriate tribunal for the purposes of Section 7. So the word tribunal is used in primary legislation and in subordinate legislation simply to allocate the 7(1)A jurisdiction, whether it's talking about a court or something that might be described in the more technical sense as a tribunal. And in our submission, that clearly supports our approach to 65(2)A. Could I just add this sort of footnote point? The appellant produced a number of additional authorities which Malone Friend didn't take you to in his oral submissions, where the word court is used to include tribunal. But those don't take one very far for a number of reasons, and I will deal with this very quickly. The first is simply that the additional authorities Malone and Friend cites are the Civil Jurisdiction and Judgments Acts and so on, which are not dealing with the allocation of the Human Rights Act jurisdiction under Section 7, so they're not in point, whereas ours are. All they demonstrate, secondly, my lords, all they demonstrate is that where the word court is used, it seems to require express provision to make it clear that it includes a tribunal. And were one to look, if you were curious, at Section 50 of the Civil Jurisdiction and Judgments Act, which is in Malone and Friend's additional bundle, you'll see that the definition of tribunal there is a tribunal of any description other than a court of law, which would rather suggest that if the word tribunal is used without more, it does include a court of law. An express definition has to be made in order to carve court out of the meaning of the word tribunal.
What was that in?
It's Section 50 of the Civil Jurisdiction and Judgments Act.
Yes.
And it's the definition of tribunal. It suggests in our submission that the word tribunal without more includes a court, which is why express definition has to be made to exclude courts in that particular context. But as I say, I'm not going to ask you to take that bundle up, because they're all dealing with unrelated matters. Those then are the first category of external supporters. The second category of, in a sense, external supporters, although it's not quite so external, external to Section 65 anyway, it's not really external to RIPA, is the procedural regime that is in place governing the conduct of the IPT procedures. It's in this context, my Lord, Lord Phillips asked yesterday, in a sense, are we really concerned with the rules? Because the issue that is before this court is the interpretation of the primary legislation. So to a considerable extent, the interpretation of the rules and what they add is of secondary importance. We have put before you the relevant bit of handling, which we are agreed, my learned friend Lord Pannick and I are agreed is the relevant authority on the point, and it's an extremely long case, so we just copied the head note and the relevant part of the speech of Lord Lowry. And if you just care to look at the foot of what is in fact page 193, although the number may have been sliced off. Yes, sorry, my learned friend reminds me that this was the leading speech with which the others, members of the tribunal, agreed. The foot of 193, letter H, there are some numbered paragraphs where his lordship said, subordinate legislation may be used in order to construe the parent act, but only where power is given to amend the act by regulations or where the meaning of the act is ambiguous. So just pausing there, if you're with me and 65(2)A is unambiguous, it means what we say, you don't need my additional points. I accept what I am making are, in a sense, make-weight points. But if you are of the view that 65(2)A is ambiguous, then we can look at the rules for what they're worth. 2, he says regulations made under the Act provide a parliamentary or administrative contemporanea expositio of the Act, but do not decide or control its meaning. To allow this would be to substitute the rule-making authority for the judges as interpreter, and would disregard the possibility that the regulation relied on was misconceived or ultra-vires. 3, regulations which are consistent with a certain interpretation of the Act tend to confirm that interpretation. 4, where the Act provides a framework built on by contemporaneously prepared regulations, the latter may be a reliable guide to the meaning of the former. 5, the regulations are a clear guide and may be decisive when they are made in pursuance of a power to modify the Act, particularly if they come into operation on the same day as the Act which they modify, which was the case here. 6, clear guidance may also be obtained from regulations which are to have effect as if enacted in the parent Act. Now, Lord, the reliance, just to make clear, the reliance that we place on the IPT rules is
just before we move on.
Yeah.
Little one. Yeah. It's really a general comment, but it's subject to what follows. It's not carte blanche wherever you've got ambiguity.
No,
otherwise you wouldn't need the risk.
Yes. Ambiguity in a sense is a sort of threshold precondition.
Yes.
And then, yes, absolutely.
Which one are you relying on?
Yes.
Well, if we pass the threshold condition, then we would say that 3, regulations which are consistent with a certain interpretation of the Act tend to confirm that interpretation. And 4, where the Act provides a framework built on by contemporaneously prepared regulations, the latter may be a reliable guide to the meaning of the former. The reason, what we are essentially saying is this, and it's partly the IPT rules, it's partly actually the Act itself, but what you get is in RIPA itself, you have an express rule-making power in section 69, which enables specific rules covering specific issues, such as non-disclosure of information, to be established for the operation of the IPT.
Well, it struck me, I must say, if I may say so, Mr. Crowe, that if you look at section 69, particularly subsection 4,
Yes.
you get a flavour for what Parliament was looking at. Speaking for myself, I'm very suspicious about looking at the rules, because a month or two went past, and I don't believe for a moment that the rules were for those who are scrutinising the legislation. But subsection 4 is quite remarkable, because it does set out a lot of detail about the things that may be done under the rules, which normally wouldn't be expected in the case of an ordinary court, which is open to public scrutiny.
Exactly.
And that really seemed to me the more important point than looking at the rules themselves.
The rules do what is contemplated in subsection 4, but yes, it is essentially the existence of subsection 4 which founds our submission. And the submission is simply that there could be no point in creating a tribunal whose rules were going to have this kind of extraordinary regime, and it isn't a normal regime, we entirely accept that. There could have been no parliamentary point in establishing a tribunal with that specialist regime if the jurisdiction of the tribunal was going to be optional. The only point in establishing the regime in this way is if it is a regime which deals with that which is conferred on it by 65(2)(a). Now, in that sense, the content of the rules, the individual provisions of the rules, don't support our interpretation in any sort of direct way. It is simply the fact that there is this specialist regime in place, and the fact that it was specifically intended by Parliament to be in place, as your Lordship rightly says, principally by reference to subsection 4, and but also subsection 6. I'm sure your Lordships have that in mind as well. 69 subsection 6, in making rules under this section, the Secretary of State shall have regard in particular to A, the need to secure that matters which are subject to proceedings, complaints or references brought before or made to the tribunal are properly heard and considered, and the need to secure that information is not disclosed to an extent or in a manner that is contrary to the public interest or prejudicial to national security, the prevention or detection of serious crime, the economic well-being of the United Kingdom, or the continued discharge of the functions of any of the intelligence services. And so there is a specific obligation on the Secretary of State to make rules effectively protecting the public interest generally, national security, intelligence functions, investigative powers and so on, balancing that against the need to make sure that proceedings and complaints are properly heard and considered.
I mean, this is a point that goes entirely to meaning 2 to defeat that, because that's the one which says you've got the option. This says ridiculous. But, I mean, it doesn't actually go to meaning 3.
No, Lord,
I'm not saying there's anything worse for that. I mean, it's just, I mean, that's the way it is.
Yeah, that's the way it is, yes. But we do regard, and realistically, we do regard the second interpretation as the only real candidate that we have to defeat. The third interpretation in our submission is dead in the water because of the wording of 65(3)(a) and D.
Yes.
And so we would submit that
unless you need it for, unless you can get there via section 3, I appreciate you're going to come to that later. And of course, I mean, that would then tie in with the fact that for certain cases, possibly, I know this is contrary to your submission, you don't actually need this sort of regime.
Lord, I will come to do it.
I appreciate that, but that's how it'll play.
I understand that.
Your argument about dead in the water because of those, I mean, I was just thinking about that. The duplication argument maybe cuts the other way. I mean, the fact that intelligence services were mentioned in 5 indicates that they were only to be within subsection 3D in challengeable circumstances, which you say are the circumstances basically falling within the Act.
Yeah.
And yet 5A is otherwise general. May that not be an argument for treating 3A as intended to operate in the same sphere?
Well, Lord, there would have been no point in having 3A at all if the jurisdiction of the IPT was confined to hearing complaints about the activities of the intelligence services in challengeable circumstances.
But you say there's no point...
That's covered by 3B.
You say there's no point in having 5A anyway.
I can't, at the moment, identify any good reason for having the intelligence services repeated in 5A, but that's not a point against me. It's a neutral point. It doesn't help either side.
Well, it is rather odd that they take, where they refer to the intelligence services the second time round, they clearly intend to do so in a limited context of the operation of this statute, but you say where they refer to it the first time round, they don't intend that limitation.
Absolutely. Otherwise, as I say, there is no purpose in including 65.3a. But, my Lord, as I say, the inclusion of 65.5a doesn't assist my learned friend.
It's dealing with the different point, though, is it not? It's the forum problem of complaints and investigations and so on. Is it not sort of rethinking the structure for that chapter of jurisdiction? Or am I misunderstanding it? Because the opening part seemed to be as it were, the judicial functions of the tribunal, which is what 2 is talking about, and 2A certainly is, and 3A.
Yes.
And the whole of 3, subsection 3. And then you get to the appropriate forum bit, which is the broader function, which is investigatory, looking at complaints and so on.
Yes.
And it's restated there. It may be rather heavy-handed, but it's done in that context. Does that make sense?
Yes, it does. Yes, absolutely. I'm grateful.
That's dealing with subsection 4, isn't it, though?
4 and 5 is linked.
Yes.
They're all these later subsections all linked into each other.
But the trouble is that, I mean, 3 is also linked into 5.
Yes, indeed.
And the point I was making was on how, actually, I think the point, which was the point you were making, how 3A, subsection 3A, reads with subsection 3D read with subsection 5A and subsection 7.
It may be that the difference is that 3A is dealing with the target of the proceedings. At 5A, just out of an absolute abundance of caution, is dealing with the body whose activities are being impugned. Now, I can't at the moment imagine a situation where you would have proceedings against any intelligence services that didn't relate to conduct by or on behalf of intelligence services.
Right.
It may well be there out of a really excess of caution. But it is, I think, on reflection, perhaps dealing with different things. One is the target of the proceedings, which is 3A, and the other is the identity of the alleged perpetrator, so to speak.
So I thought your point is 3D deals with everything that actually is regulated by RIPA, challengeable circumstances.
Exactly.
D is where you need all your warrants, authorities, and all the rest of it. And therefore, you actually, logically, you read 3A necessarily as wider than that.
Exactly.
And that is the answer, you say, to meaning 3.
Exactly. That's my point. Exactly.
Yeah, and my point was the opposite, which I think is clear enough, that it's very odd to regulate something very specifically and to limit it to a particular, in a particular way, and then say, well, actually, it wasn't necessary to do so at all because we've covered the whole thing in a much wider basis earlier.
Yes. Yes. Lord, well, there it is.
Yes, there's the argument.
Going back to where we were, Lords, the point that I was, in a sense I've made the general point. It's the fact that the primary legislation expressly contemplates this specialist regime that is a powerful indicator. It clearly carried force with Lord Justice Dyson. We would urge your Lordships to accept the force of the submission, that there is a very detailed regime. Essentially, the features of the regime are specifically designed to achieve the twin purposes in subsection 69(6), which is, on the one hand, to impose appropriate restrictions in order to safeguard the public interest, and, on the other hand, to provide an effective, penetrating scrutiny of the service's conduct in a manner which provides adequate safeguards to counterbalance the restrictions that have to be put in place. Lords, without going through the regime in inordinate detail, can I simply list for you the headline points that we would urge on your Lordships as being the significant features of the regime that achieve those twin purposes of fair scrutiny and protecting the public interest. The first is simply the constitution of the IPT panel itself. These are all effectively covered in our case in various places, but if I could just list them to you in a sense as bullet points. The constitution of the IPT panel, these are senior members of the judiciary or senior practitioners. The chair has to be the president has to be someone who's held or holds high judicial office, and your Lordships know who it is. The specific provisions that make these requirements are in Schedule 3 to RIPA, so I'm not here relying on the rules. It's Schedule 3 to RIPA, paragraph 1, and paragraph 2 and paragraph 3, which are all on page 301 and 302 of the appendix. Secondly, what is crucial to the efficacy of the tribunal is the powers of obtaining information. And the information obtaining powers derive again principally from the Act, from RIPA section 68(6). We have a duty directly imposed on every person holding office under the Crown to disclose or provide to the tribunal all such documents and information as the tribunal may require for the purpose of enabling them to exercise the jurisdiction conferred on them. So there's an absolutely unqualified right on the part of the IPT to demand information from Crown officers. There is also, although given that it is probably unnecessary, there is also a power on the part of the, a duty on the part of the commissioners to cooperate, and that's section 57(3) and 59(3) of RIPA. The duties are the commissioners are under an express obligation to cooperate with the IPT, and for that matter, officers of the services are themselves obliged to provide documents and information to the commissioners under sections 58(1) and 61. So there is, both directly and indirectly through the commissioners, a very powerful tool for obtaining information. Thirdly, admissibility of evidence is wholly unlike ordinary court proceedings. As my Lord Panic pointed out yesterday, the first critical point is that RIPA intercept material is admissible, section 18(1)(c), which is not the case in any ordinary court. And secondly, the normal rules of evidence that apply in court do not apply, and that's Rule 11 of the rules. That's one of the few rules I do need to refer to in this context. But given the effect of section 68(6) that we've looked at, it must inevitably be so, and we do accept that PII is not a bar, is not an answer to a demand from the IPT for disclosure from the services. So the IPT has, in a sense, perfect vision of material which a court will never see. And in our submission, that is a critical element in providing a safeguard against the restrictions which are in place in the public interest to prevent inappropriate disclosures of sensitive material. Fourth point in the regime that matters is that the test applied by the IPT is the same test as the court would be applying in judicial review proceedings. That's RIPA section 67(2). Those are all, in a sense, significant points in our favour. There are the counterbalances, the restrictions. Your Lordships have seen the restrictions on the ability to give open judgment in section 68(4). but it may be worth also just pausing, because what section 68(4) does is in fact a qualified restriction. It says, where the tribunal determine any proceedings, complaint or reference brought before or made to them, they shall give notice to the complainant which, subject to any rules made by virtue of 69(2)(I), shall be confined, as the case may be, to either a statement that they have made a determination in his favour or a statement that no determination has been made in his favour. So simply as a matter of primary legislation, there is no absolute bar on the giving of reasoned judgments, because the restriction in 68(4) is subject to any rules made by virtue of 69(2)(I). 69(2)(I) is over the page 268, which provides that rules under this section may require information about any determination of order or other decision made by the tribunal in relation to any proceedings, complaint or reference to be provided to the person who brought the proceedings or made the complaint or reference, or to the person representing his interests. So there is, it's not just looking at the primary legislation regime, there isn't an absolute bar on giving reasoned judgments. And that, in our submission, when I come to deal with the ECHR challenge, that right at the end of our submissions, that in our submission is a critical point.
Can you just help us through? I mean, under that 69(2)(I), did the initial rules, in fact, qualify 68(4)? They did, didn't they? I mean, and then again, it had to be used to meet the problem. So has it, I would like just to get that straight. Right. I mean, I think initially, if the complainant won, he got some reasons, and that must have been under the 2000 rules.
Yes, I think that's right. Is that rule 13? I'm grateful. Thank you.
So can we?
Yeah, that's page.
That's right. 13.2.
Yeah.
So it was used in 2000 for 13.2.
Yeah.
For Rule 13.2, and then again to deal with the business about when they rule on a point of law.
Yeah.
Was it used again, or that power, or was it just that the tribunal rewrote it?
I'm not aware that it has yet, Lord. I'll certainly check that.
I see.
But again, what I want to simply park the thought with you, that is what the primary legislation contains, and then revisit the significance of that when I'm dealing with the ECHR issues.
Okay.
Could I catch you just, if I might, to identify the rule-making power that allowed Rule 11 to be made? This is the evidence one, receiving evidence in any form, and so on and so forth. Am I right that it's in 69(6)(A)?
That certainly would be, if there's nothing else, yes. Certainly. I don't think
things are properly heard and considered, and of course it's subject to B, which is the qualification, securing that information is kept confidential.
Yeah.
So it's a very broad power.
69, which?
69(6)(A).
No, 6A. Right.
That seemed to me the widest power, but maybe another one.
Might be 69(2)(G as well, prescribe the practice and procedure.
It's not quite so...
yes, and
including where applicable the mode and burden of proof and the admissibility of evidence. So yes, there is that.
69(2)(G.
Yes, right. Yeah.
Thank you.
Yeah, thank you.
My Lord, the detail of the regime you've already been taken to, but by way of, in a sense, by way of complaint about the restrictions in Rules 6, 9 and 13. We would say that they are simply part of the package which seeks to do what Section 69(6) requires, which is to find this balance between the interest, the public interest, the aspect of the public interest that requires non-disclosure of certain things, and the aspect of the public interest that requires open justice. But, Lord, the points that we make by reference to the primary legislation setting up the IPT is that once one accepts, as we submit, that the IPT is an appropriate body in the non-technical sense because of this specialist regime. It is the appropriate body to hear the kind of case that this case certainly is. There would be no point in having set it up if, in fact, it was an optional regime. Why on earth should Parliament have intended that result? In our submission, there simply isn't a plausible answer to that, unless one is driven to that conclusion by the ECHR considerations, which I'll come to in a moment. So, as I say, the external indicators, by that I mean external to Section 65, comprise the other legislative provisions we've looked at and the IPT regime as a whole. The third main heading I wanted to address you on is simply whether or not there is any authority to assist you. And simply on this point, we wanted to make two very short submissions. The first is that in the written cases from the appellant and from Justice, one saw a considerable amount about the Shaler decision. In our submission, that can be and should be dealt with by your lordships extremely shortly, simply because the question of the interpretation of Section 65 was not before the House on that occasion. It was simply not raised by any party, the House didn't decide it, and there is nothing that you actually gain from a study of the judgments, the speeches in that case. The worst that can be said is that the Secretary of State in that case should have pointed out to the court that Section 65 had by then come into force and consistent with the argument advanced by the respondent in this case, the Secretary of State on that occasion, could have argued that judicial review wasn't the right way forward, but that proceedings in the IBT were. The short answer to that, Lord, is that, if anything, it is a criticism of the Secretary of State in that case. It doesn't assist you on the interpretation of Section 65 now. But in any event, it's not a fair criticism of the Secretary of State in that case, because, as your lordships are aware, the disclosures made by Mr. Shaler were made in 1997, and the question that was being addressed was whether or not somebody in the position that he had found himself in, and then being prosecuted for having done what he did in 1997, had the legal issue was the question of whether or not there was a public interest defence under the Official Secrets Act. And that, simply, that's what the ratio of the case is about. And so that has to be tested by reference to the circumstances as they existed when the disclosures were made, which was before the Human Rights Act and before RIPA were passed. And so, as I say, although it's an unnecessary point to make in a sense, any implied criticism of the Secretary of State is misplaced because RIPA was not a relevant consideration in Shaler. But as I say, even if it was a relevant consideration in Shaler, the most that my learned friend can get out of this point is that the issue that was decided in Shaler under the Official Secrets Act might be open for re-argument. But in our submission, your lordships should not say anything to encourage that. It is not a point in any event that assists you on the interpretation of the legislation you're dealing with. So in terms of authority, you get nothing from Shaler at all. The only passing point that we would seek to make is actually in a case my learned friend Mr. Miller mentioned, which is C and the police. Your lordships may remember this was the police officer who made a disability claim under his pension rights. The police authority thought he was malingering and had him filmed, mowing the lawn and so on. In passing, I'll just, it's bundle 1, tab 6. I don't particularly ask you to dig it out, but because the point doesn't appear to have been argued in any detail, but it is perhaps worth noting that in paragraph 19, the way the IPT put their own jurisdiction was to say this. They say means of redress for persons aggrieved by the use of investigatory...
Sorry, paragraph 1?
Sorry, 19, bundle 1, tab 6, paragraph 19. Means of redress for persons aggrieved by the use of investigatory powers are provided by the tribunal on which there is conferred jurisdiction to consider and determine proceedings and complaints. For the purposes of certain proceedings under Section 7(1)(a) of the 1998 Act, For actions incompatible with the Convention, the Tribunal are the only available forum. So they choose to use the word forum, which clearly captures the concept that we are urging on you. And that's not just a passing remark, because they revisit it at paragraph 27, where they say the same thing, and then they quote. In paragraph 27, they say again, as set out in 19 above, for certain kinds of complaints and proceedings, the Tribunal are the only appropriate forum. Their proceedings are governed by the rules about which more is explained in later paragraphs, and then they set out 65(2)(a) and B themselves. So it is of slight assistance. I'm not suggesting it is in any way binding or determinative, not least because the IPT doesn't regard itself bound by its own rulings. But, my Lords, insofar as anybody has passed judicial comment on the issue other than the courts in this very case, it provides some support for us. So, my Lords, that is the third heading we wanted to address you on, authority, which leaves the fourth heading, which is whether there are any grounds for rejecting what we submit is the plain meaning of section 65(2)(a). Although there was a certain movement in the submissions on behalf of the appellant, broadly we would suggest that their arguments are grouped under three headings, and we want to deal with them in this way. The grounds, they say, that exist for rejecting the plain meaning of section 65(2)(a) consist, first of all, of their argument of ouster. Secondly, because they say that the Court of Appeal's interpretation leads to anomalies. And thirdly, although my Lord Panic took the lead on this, they say that the claimant's convention rights require a different interpretation to be adopted. So we just wanted to address you in the remaining time under those three headings, starting with ouster. And this was the point that troubled Mr. Justice Collins. He said that our interpretation involved an ouster of the jurisdiction of the ordinary courts. I wasn't involved in the Court of Appeal, but it appears to have had a slightly quieter outing then, and it certainly got short shrift from the Court of Appeal. And in our submission, entirely rightly so, we have four short points that we would wish to urge on you in relation to ouster. The first is that our interpretation, the Court of Appeal's interpretation of section 65(2)(a), does not involve any general ouster of the court's jurisdiction. It is simply concerned with a specific statutory remedy under section 7(1)(a). It does not purport to oust the court's jurisdiction in civil litigation more generally. And essentially that is our first and main point. The position under section 65(2)(a) can be contrasted with the position that arose in the case of Pick's Granite, which was one of my learned friend's authorities in his printed case. He didn't take you to it in oral submission, but we would like to do so because in our submission it actually supports our position on this. Pick's Granite is bundle 2, tab 22. And the issue that arose in this case, as a matter of statutory interpretation, was the question whether or not a statutory provision which enabled the Secretary of State to determine whether or not somebody needed planning permission in order to conduct specified operations, whether that statutory regime excluded a ruling on that question by the court. And so the factual context in which the question arose was exactly the opposite of this one, because ours is a case where the court is where Parliament is allocating a specific statutory remedy under Section 7(1)A, whereas this was a case in which the question arose as to whether or not a specific statutory remedy, so to speak, the determination by the Secretary of State, was the only way of determining what was the right under the general law of the complainant in that case to develop his own land. Now, there are a number of different issues that were discussed, most of which aren't relevant. If I could just to give you the structure of the judgment, the leading speech is given by Viscount Simmons, which starts at page 282. And the first question that he discusses is not relevant to us. The relevant passage starts at page 285. It's the second question at the foot of page 285. I'm not proposing to read the whole of 286 and over to 287, but it, in our submission, supports the approach that we're urging on you, that ouster is not a concept which is concerned, that this case does not support my learned friend's argument because it is dealing with a different situation, and the fact that it's dealing with a different situation emerges clearly from the bottom of page 286. So I do urge on you the whole of his lordship's reasoning here, but if you just look at the last 4 lines on 286, where he says, "It appears to me that the case would be unarguable but for the fact that in Barraclough and Brown, upon a consideration of the statute there under review, it was held that the new statutory remedy was exclusive. But that case differs vitally from the present case. There the statute gave to an aggrieved person the right in certain circumstances to recover certain costs and the expenses from a third party who was not otherwise liable in a court of summary jurisdiction. It was held that that was the only remedy open to the aggrieved person, and that he could not recover such costs and expenses in the High Court. I do not think," said Lord Herschel, "the appellant can claim to recover by virtue of the statute, and at the same time insist upon doing so by means other than those prescribed by the statute, which alone confers the right. Or, as Lord Watson said, the right and the remedy are given uno flatu, and the one cannot be dissociated from the other." So where a right and a remedy are conferred in one breath, as they are under the Human Rights Act, his lordship is saying there is that there isn't a question of ouster there, because it is simply, as we urge on you, a question of allocating the jurisdiction to determine a remedy which the Act itself is conferring. And so in our submission, our case is exactly comparable with the Barraclough and Brown case, where Lord Herschel said that the appellant can't claim to recover by virtue of the statute, in this case the Human Rights Act, and at the same time insist upon doing so by means other than those prescribed by the Human Rights Act, which alone confers the right.
So it's really working through Article 13, is it? I mean, it's making sure you've got an effective remedy and telling you where to go to get it.
Yes, exactly. And so, in
but I mean, the actual points made, I mean, they may be good or they may be bad, but they're not quite that point. I mean, as we said yesterday, I mean, there are 2 aspects. One is, well, there it is, you had a pre-existing common law right anyway, which you could have brought to the courts, but now, if you're right, you can't any longer. You can only bring it in this tribunal. And the other argument, of course, was that, there it is, the rule says court, and here,
but the answer to the first point is that Section 65 isn't dealing with whatever common law right might previously have existed. Section 65 is only doing what Barraclough and Brown is talking about, is allocating the jurisdiction to determine a completely new, self-standing statutory remedy. So it's not seeking to oust the court's jurisdiction in relation to civil jurisdiction generally. It is only dealing with Section 7(1)A claims. And that's why, in our submission, no question of ouster arises. It is, I think I said I had 4 points. I think I probably only got 1, looked at from a number of different angles. But the point is that this was essentially Lord Justice Law's analysis, that the grant of, or the creation of the concept of convention rights. The obligation on public authorities not to act incompatibly with them, and the statutory remedy, if they do, are all creatures of statute. What Section 7.2 of the Human Rights Act tells you is, well, you've got to go to an allocated place to make that complaint. Section 65.2a tells you what that place is. And they are uno flatu, they're done in one breath in the sense they all happen on the 2nd of October 2000. They're not actually within the same statute, but they are exactly part of the same statutory regime, which is put in place in order to ensure the convention compatibility of the functions of the security and intelligence services. And in our submission, that is exactly why this case is different from the Anis Minnick case, because what Anis Minnick was dealing with was a provision which purported to immunise a lower tribunal from scrutiny by the ordinary courts. And that is not what Section 65.2a is doing. It's got nothing to do with immunising the IPT from scrutiny by the ordinary courts. It is exactly a question, and there is another illustration which my Lord Phillips and my Lords Mounts and Lord Hope may recall, the case of Farley, where a related point arose, which is in the same authorities bundle 2 at tab 11, where again this question of allocation arose. The question, the principle of ouster doesn't apply, where what is being done is an allocation of remedial routes rather than a deprivation of the courts, the ordinary court's jurisdiction. Lord, it's quite a short case, but I would again, without reading it, the relevant statutory provision is in paragraph 6, and the relevant passages are paragraphs 16 to 18 of that judgment. I wasn't going to read them out to you. But our submission is that is of a piece with the analysis in Barraclough and Brown. It's of a piece with the analysis of Lord Justice Laws, that the principle of ouster is simply inapplicable where what you're talking about is an allocation of jurisdiction in relation to a statutory remedy, rather than what was happening in Anis Minnick, which is a provision which expressly purports to exclude the review of an inferior tribunal.
I mean, the Anis Minnick point goes surely not to, it goes to 67.8.
Well, exactly.
Yeah.
Lord, if somebody wants in another case to have a go at section 67.8, well, so be it. But that isn't what this case is about. That's the short answer. The other aspect that Lord Justice Laws found compelling, and we would urge you on urge this point on, it's part of the sort of same sort of Farley point, is simply that if one is looking at allocation, the question of whether or not you feel comfortable and whether or not it is to be regarded as an objectionable ouster will partly be informed by the standing and the nature of the tribunal to which the allocation is made. That's a point Lord Justice Laws makes in paragraph 22 of his judgment. And in our submission, if one takes that point on board and one looks at the standing of the tribunal, of the IPT, one sees in Schedule 3 the express requirements that the President must be someone who holds or held high judicial office.
I don't follow how the standing of the tribunal is relevant to whether there's an objectionable ouster.
Lord, if one simply took a more extreme example, if I were in the position of having to try running if this point arose in the situation where the tribunal was not an independent tribunal in such as to satisfy Article 6, nominees appointed by the Secretary of State directly or appointed directly by the security services themselves, then the standing of the tribunal would infect the assessment of whether or not one was genuinely talking about an allocation as between tribunals, as between courts, or whether one was actually looking at a situation of ousting the courts in favour of something that was plainly inferior. I think that's the thought process behind Lord Justice Law's observation. It goes, in a sense, to the point that Farley is making, is that one looks at the efficacy of the remedy that is being put in place. if there is an adequate remedial process, and part of that question is, well, is it an adequate tribunal? Then one isn't concerned by the anosmic issues. And the final point on this, in a sense, it loops back into my very first point, is that my Lord Panic's point has been that the effect of our interpretation is supposedly that the public law jurisdiction of the administrative court would be ousted by our approach. And in our submission, that is simply not the case, because, as I say, Section 65 does not purport to deal with the public law jurisdiction of the administrative court. If the administrative court receives an application which is dressed in the clothing of an ordinary public law claim, but is in fact the real beast, is in fact a Human Rights Act complaint, the administrative court has a discretion to decline jurisdiction, because the administrative court exercises a discretionary jurisdiction. So the admin court could say, well, no, actually, you've got an alternative satisfactory remedy, go to the IPT. But that's not a question of ouster, because it is not Parliament dictating to the administrative court what to do. It is simply Parliament putting in place the IPT regime and then leaving it to the administrative court in any particular case to decide whether or not the IPT is such a suitable alternative remedy that judicial review should not proceed in that case. But that's not ouster.
It's one of the unsatisfactory features of this of the scheme as it is at present, in the absence of any order under Section 65(2)(d), is that in fact the administrative court couldn't decline jurisdiction in respect of non-human rights claims on the basis that they could be adjudicated by the tribunal, because they couldn't be, could they? They wouldn't.
Lord, the answer might well be in that situation that the admin court may say, well, all right, you can't bring proceedings under 65(2)(a), but you could describe the same thing as a complaint under 65(2)(b).
Well, I thought you said a moment ago that a complaint was confined to non-legal.
Well, Lord, that which gives you a legal right to bring legal proceedings does not have to be presented as a legal claim. Exactly the same gravamen can form the subject matter of what is a complaint, which then triggers a slightly differently described jurisdiction in the tribunal. But there's no reason why an interference which could ground an action alleging, well, could ground judicial review, could not also be simply brought as a complaint. I don't like what you have done, and the tribunal would consider it under B.
So, can the tribunal give all the remedies that would be
remedies are
available in ordinary proceedings if it's not treated as a legal claim?
Sorry, I just need to get... The remedies are in 66. Yeah, I think, yeah, 67(7), my Lord, bottom of page 264.
Yes.
Subject to any provision made by rules under 69, the tribunal on determining any proceedings, complaint or reference shall have power to make any award, any such award of compensation or other order as they think fit. So the remedial powers are covered by the same subsection, whether it's a complaint or proceedings.
Doesn't that run you into the difficulty then that the tribunal is actually the appropriate forum for complaints?
Yes.
Are you saying that if you call something a complaint, then the only place you can pursue it is the tribunal, but if you call the same thing a legal claim for judicial review or for common law damages, you can bring it in the ordinary courts.
If it isn't a Human Rights Act claim in
Yes.
sheep's clothing, yes.
Yes. That is the consequence.
That is the consequence. We have to face up to that.
But
I mean,
how do you know if it's a human rights claim in wolf's clothing, in sheep's clothing?
Well, you do what Mr. Justice Collins did in this case, and you subject it to a critical scrutiny, identify what its real gravamen is, and make effectively a value judgment.
Well, what box is ticked? It is not that exercise, really. You've got to go and see the substance of the claim.
Yes,
In
one's
words.
got to identify what is being complained about.
Yes.
And one has got to look at what test the complainant is asking the court to exercise. Because if the complainant is asking the court to reach the conclusion that there has been an interference with the right to freedom of speech which is disproportionate, one is looking at Article 10 language. If one is looking at a claim where the complainant is just saying, well, you didn't like me ever when I was your employee and you simply decided this way because you're biased, one looks at the substance of the complaint and one makes an evaluation as to what its content really is.
At the moment, I'm not persuaded that there is much difference so far as the test is concerned with a pre-human rights claim of this nature and this claim. Whether you call it proportionality, you're looking at whether there's justification for saying, no, you can't publish this in the public interest, aren't you?
My Lord,
You're going to get a different answer if you say it's all about proportionality.
my Lord, it is well recognised that the test of proportionality is considerably more intrusive than the conventional judicial review test of irrationality, certainly. That is unquestionably the case.
But I mean, just going back to the question I put you much earlier, I mean, just assume this publication here had been sought, you know, in July 2000 instead of under the Human Rights Act. I mean, then the claim would have been, the whole thing would have been dealt with in the court.
Well, unless one is working, part of the subtext of a lot of the points that were being made against us is that the IPT is necessarily an unattractive tribunal, and that, you know, right-minded complainants will automatically opt for the ordinary courts. Part of the reality check one gets from C and the police is that is not necessarily so. If my learned friend was postulating these slightly fanciful hypothetical cases of the police snooping in a hotel bedroom and investigating, it's rather more helpful to look at a real case. A real case of a non-criminal investigation by the police, which came up with this decision, was actually C against the police, in which it was actually the complainant who wanted to be in the IPT, and it was the police who said, no, the IPT doesn't have jurisdiction. Yeah. It does matter, because it does illustrate that the balance has been successfully struck, as we would submit, in relation to the setting up of a jurisdiction for a tribunal that does provide a suitably penetrating investigation of the kind of activities that are captured.
No, I'm sorry, my question was on this. I mean, I was just simply assuming that this is all before the Human Rights Act, before RIPA, though. Yeah. Before Section 65.
Yeah.
The equivalent of A here wanted to publish. And he was told he couldn't, so he would go to court.
One can only speculate. He could have complained to the Security Service Tribunal.
Oh.
So, and Section 65(2)(b) is the successor jurisdiction to that. So, one is speculating. You know, if he was of the same mind as the policeman in C and the police, he may well have preferred the complaint to go in the tribunal, because he would know that the tribunal would have full sight of the arguments on either side.
But you wouldn't say he would have to. He could have gone to court.
In pre-Human Rights Act, yes, he could, unquestionably. But you know, that's the world in which we are living. I mean, we are only arguing about what the Human Rights Act, twinned with RIPA, has achieved. That is the only question. We are not saying that Section 65(2)(a) forces what can properly be described as common law claims into the IPT. It certainly gives the discretion to the administrative court to say that the IPT provides a suitable alternative remedy.
But I mean, what happens if he goes in the Chancery Division for a declaration, or that he's entitled to publish, or whatever? I mean, damages for the delay in giving him permission, all the rest of it. I mean, that's not a discretionary remedy.
No. No, damages wouldn't be.
So how is he then stopped from using his Article 10 rights in connection with that claim?
My Lord, I wouldn't want to give a sort of a blueprint for that's going to cover every hypothetical situation. First question is, in reality, is that kind of thing going to be happening? Are there going to be real cases where somebody has in fact got a cause of action that is suitable to the Chancery Division that might otherwise have fallen within the jurisdiction of the IPT? Seems a highly improbable situation. If, in fact, a case is brought in the ordinary courts, which is genuinely not a Human Rights Act complaint, then Section 65 has no impact on it.
But I mean, you might very well say in those circumstances, actually, the court proxy could regard it as an abusive process.
Well, that was one of my learned friend Mr. Miller's observations, that the answer may well be, even if you're not in the admin court, that it could be met by an abuse, or if the issue was of genuine concern, then it might spur the Secretary of State to do what he hasn't so far done, which is to bring Section 65(2)(d) into force and assign that claim or that class of claims to the IPT. But all that demonstrates is that the Act itself contains a regime under 65(2)(d) which is capable of dealing with what at the moment are unforeseen circumstances. None of that, I would urge on you, assists you in deciding what 65(2)(a) means. So, Lords, our submission is that... Sorry, could I just pause, actually, because there was some... there has been certain confusion, certainly on my part, as to how long you're expecting to hear from us. I had thought this was down only for a day and a half, and I had thought... No, good. Because our estimate was always 2.5 hours, so if we were closing at 1 o'clock, that would leave my learned friend little time to reply.
We have the whole day allowed for this.
I'm relieved to hear that. My learned friend is probably more relieved to hear that. Lord, the second heading...
Are you leaving this topic? Because I'm not absolutely sure where we are.
Ulster. I am leaving Ulster.
Yes, I mean, it's a question of how you identify whether this is something that is brought for the purposes of Section 7 of the Human Rights Act, and is it too simple to say that it's not just a question of ticking the box, but you look to see what remedy is sought, and you look to see what the grounds are on which that remedy is sought, and you look at the way the claim is formulated. And would I be right in thinking, certainly it would be the case in Scotland, that you wouldn't be allowed to pursue an argument in relation to a convention right unless you mentioned that somewhere in your claim?
Lord, yes, I think what the court would have to do would be, as I say, exactly what Mr. Justice Collins did, which was it is to consider whether, as a matter of substance rather than as a matter of form, yes, the person was claiming that a public authority had acted in a way which was made unlawful by Section 6, yes. 6.1.
You may have different grounds all brought in, but he would say, or you could say, well, so far as the chapter that relates to Section 7.1a is concerned, that must go to the IPT, and you would perhaps ask for the remainder to be stayed until that matter had been dealt with. Would that be right, or vice versa?
Yes.
But one way or another, you can sort it out by examining the way in which the claim is formulated.
Yes, so what one would be looking at would be, yes, the question of form, namely, have they in fact ticked the box, which in this case they have, saying this is a Human Rights Act claim, and then one would be looking also at the question of substance, because form would not dictate the answer. One would look at the question of substance as what is the nature of the impugned act, what is the nature of the challenge, what is the real content of the challenge, and what is the test that thirdly, what is the test that the complainant is asking the court to apply?
The important point in this area, I suppose, is that the most promising claim, the easiest claim to establish for a claimant, is likely to be the one under the Human Rights Act.
I think many claimants take that view.
So that that would be the one which normally, if one had to choose, would be primarily dealt with.
I mean, Article 10 is an altogether more promising basis for a claim to publish than irrationality, isn't it?
It may well be.
Well, not necessarily, because I mean, you don't have to be irrational in order to fall foul of an Article 10 prohibition.
No.
When you look at the grounds for judicial review, they're
in this
looking at
case,
Shaler. What?
In this case,
yes.
Yes.
They're looking at Shaler, what the House of Lords said as regards your right to judicial review in these circumstances, not based on the Human Rights Act at all.
If one looks at page 10, paragraph 10.
Yes.
That's in the chapter headed Legal Framework, isn't it, the decision?
And paragraph 21. One sees so there's an express citation of Article 10 in paragraph 10, paragraph 21b. The refusal to authorise publication is neither necessary nor proportionate in the interests of national security, which we apprehend. That's why I say that one looks at the question of substance as to the tests.
Taylor couldn't possibly bear on the substantive complaint, could it?
No. So, Lords, if I can move on from Ouster, as I said, under this fourth heading, the various grounds that have been advanced for departing from what we say is the natural meaning of 65(2)A. The first was Ouster, which I've dealt with. We say that just isn't an issue. The second is that there is said to be a string of anomalies which arise, and those are explored at some length. We can answer them, but essentially our overall submission is that there simply aren't, if one is imaginative enough and one invents hypothetical cases, one can no doubt come up with hypothetical factual situations that might make some particular statutory interpretation look surprising. But our principal answer to this whole line of anomalies arguments is to say, well, is anything that is being put forward in fact a plausible means of testing the interpretation? And does it produce such a surprising result that you are driven from what we say is the natural meaning of section 65(2)A? Are you being invited to test the interpretation by reference to real cases, or plausible cases? And secondly, is the result, as I say, so surprising that you must be driven from what we say is the natural meaning?
What about the injunction, or do you want to spend that till we get later in the argument?
Sorry, Lord,
What happens if you're enjoined against publication and you want to use Article 10 to say that you wouldn't properly be enjoined?
Well, Lord, that is, I think, one of the points that is raised against us.
It is. We asked you earlier, and you said you'd like to deal with it when you come to anomalies.
Absolutely.
You've got that.
Yep, we have. I'm happy to deal with it immediately. The first answer to that, my Lord, is that the peculiarity, insofar as it arises, actually arises by virtue of Section 7 of the Human Rights Act, not by virtue of section 65(2) of RIPA, because Parliament has chosen under section 7(1) of the Human Rights Act to make this division between claims, effectively, bringing proceedings, which can only be done in the appropriate court or tribunal, and relying on convention rights, which is effectively in para 7(1)b, which is defensive. So insofar as there is any anomaly that is being alleged, it is an anomaly that doesn't flow from our interpretation of section 65, it flows from Parliament's choice in the Human Rights Act to treat those two different uses of the Human Rights Act in deliberately different ways, and to assign one to the appropriate court, which by definition is going to be an exclusive exercise. However you assign it, it's going to be an exclusive exercise somewhere. And secondly, the merely relying on convention rights, which you can do in any legal proceedings wherever they happen to be brought against you. So our first answer, as I say, is that it's not a point that can be made against our interpretation, because it's a point that flows from the Human Rights Act, and it flows from the fact that however you interpret 65(2)a, there is exclusivity in it. So there is bound to be some element. Section 7(1), A and B, is going to impact in the way you've described, however you try squaring it with section 65(2). So it's not a point against my interpretation, it is simply an observation about section 7(1) of the Human Rights Act. The second point in relation to the counterclaim issue is that, again, one's got to come back, well, is it likely to be a real issue? If one takes, for example, the Shaler case, civil proceedings, let us say, are brought, as indeed they were, brought in the ordinary courts, because that is where the proceedings needed to be brought. In order to defend those proceedings, Mr. Shaler could, I suppose, have counterclaimed for a declaration that he was entitled to do what he was doing because he was whistleblowing. But and if he had counterclaimed, the effect of section 7(1)a would have been that that would have had to be consigned to the IPT. But in order for the issues... He wouldn't, exactly, that was the point. There would be no point in counterclaim. That's my second point. Is that whether or not...
the same issue, whether he counterclaimed or not.
Exactly. It's purely a matter of choice for the defendant to put himself in this jam. If he doesn't counterclaim, he defends in the ordinary courts where he is being sued. So the problem in the real world isn't going to arise.
I'm terribly. Why doesn't it arise?
Well, the point, as I understood it, that was being made against me is that our interpretation produces this odd anomaly that if the security service sues, that goes in the ordinary courts. But if the defendant counterclaims, the counterclaim's got to go to the IPT. So this is suggested it's just a...
Why isn't that an oddity and an unsatisfactory one?
Well, my Lord, as I say, because, first of all, it is an oddity that flows from Section 7. It doesn't flow from our interpretation of Section 65. It flows from the fact that Parliament has specifically chosen in Section 7(1)a of the Human Rights Act to say that proceedings for a breach can only be brought in the appropriate court or tribunal. So once you've identified an appropriate court or tribunal, whether it's our interpretation or somebody else's interpretation of 65(2)a, having an appropriate court or tribunal being the only place you can bring section 7(1)a proceedings is going to have a problem if you then counterclaim when you're being sued in a different court or tribunal. That bifurcation arises because of the division between 7(1)a and b. And as I say, it doesn't... the second point is the point my Lord Clerk has made, which is that in reality it's not a problem that's going to arise, because if a defendant is sued by the security services, he can run all the issues he needs to run by way of defence without visiting upon himself the inconvenience of being assigned to the IPT by bringing a counterclaim, because whether he brings a counterclaim is up to him. And he can run all the issues he wants to run based on the Human Rights Act by way of defence.
Yeah, there's still the anomaly that all the issues when he runs the defence, again to be explored in a public court. You say that's part of the Human Rights Act, and when you try to assign jurisdiction to a specialist tribunal, it's unavoidable because of.
Well, it's odd though, isn't it? Because part of the argument is that this was all, at the moment these two statutes came into force, it was all part of one statutory scheme. Well, so it's very, very odd if one's trying to read things together and arrive at a coherent whole. It's very, very peculiar indeed, and it may point to a different construction of Section 65. Well, because otherwise, why didn't they simply amend Section 171B by extending it to defences?
Well, my Lord, as I say, in our submission, it's
very odd, but no.
It produces difficulties. Hypothetically, it is capable of producing difficulties. And in reality, in our submission, it is not going to.
Well, it depends how brave the person in A's position is, maybe. Lord, as I say, it is very difficult to argue. He says, I'm going to publish on Friday. Then it's over to your side to decide what they're going to do.
Well, in an immediate situation like that, if the publication would cause sufficient damage, then proceedings would be brought as they were against David Shaler. Right. But again, Lord, as I say, the third answer, apart from the fact that it's not a problem that's caused by our interpretation of 65(2), and we don't understand how it can be resolved by any other interpretation. Secondly, as I say, it is not a problem that is likely to arise because if the complaint is, the defendant, don't want to have to bring a counterclaim in the IPT, the answer is, well, don't bring one. The third point in response to this alleged anomaly is that if, contrary to our expectations, there is a claim or a class of claims which does cause such an anomalous problem in this regard, then 65(2)(d) provides the statutory way of squaring it. And what you're not sitting here to judge, with respect, whether or not the Secretary of State has so far made a good decision in not bringing 65(2)(d) into force. All that is open for debate is what does Section 65(2)(a) mean? And if there is a regime under which any supposed anomalies with our interpretation of 65(2)(a) can in fact be resolved within the framework of the primary legislation, then in our submission you don't have to worry about these hypothetical alleged anomalies.
How does Section 65(2)(d) deal with the injunction case? I mean, you say it's not a practical problem, but I mean, the practical problem is that if you have to enjoin, then you're stuck as a security service with having to meet the defence of Article 10 in the ordinary court.
Well, sorry, my Lord, that's a different point. Yes, I agree. That's a different point. That's not the counterclaim point. That is simply, that's a separate point. That is saying that in a sense, consistent with our argument, it would be nice, in a sense, if 65(2)(a) had gone further and required the security service to bring any proceedings that it might choose to bring in the IPT.
Can this be dealt with under 65(2)(d), you say? How does Section 65(2)(d) meet Section 7(1) of the Human Rights Act?
I don't think it can come within D, can it?
No, I don't think. Sorry, I don't think. I wasn't suggesting that 65(2)(d) could be used to force the security service to bring proceedings in the IPT,
or to enable them to.
No, indeed.
So I mean,
so
it couldn't be used to deal with this particular.
I think we've been at cross purposes. Sorry, Lord, I'm afraid we've been at cross purposes as to what the mishap is. I thought the point being put against me was that we sue in the ordinary courts. If they counterclaim, they have to claim in the IPT, and that is a mismatch of procedures. Your Lordship's point, I think, is a separate one, which is, as things stand, we have to sue in the ordinary courts, and if we're so concerned about national security, isn't it odd that we do have to sue in the ordinary courts? Well, my Lord, that may well be right, but it's not an issue that Ripper was dealing with. RIPA and the Human Rights Act are dealing with cases that go the other way. They're dealing with complaints against public authorities. So by definition, they're dealing with the jurisdiction of tribunals to deal with complaints where a citizen is complaining about the conduct of the public authority. They're not empowering public authorities to sue private individuals. So the focus of both the Human Rights Act and RIPA are by definition on the functions of the IPT as the place where you go if you're complaining against the security service.
Unless you're doing it by way of defence, raising all the very same points.
Yeah.
It's very, very peculiar.
Yeah.
But I suppose at least the security services have a choice whether to bring proceedings, and they can...
Exactly. They obviously will need, as they do in any case, to take a view as to whether the bringing of the proceedings is going to be fraught with so many difficulties that the public interest is better served by not bringing them.
And there may be a difference, actually, on the ground that needs to be covered by way of defence, as opposed to a ground that needs to be covered by way of proceedings brought by the individual to meet the injunction point, for example.
Yes.
It's difficult to envisage without a practical case before us, but I can see situations where the injunction, the request for it could be met by a fairly limited defence, which would be enough to defeat the injunction.
Yes.
But it might lead to other issues that would have to be decided elsewhere.
Yes. Yes.
That's possible.
It's certainly possible, Lord, yes. Lord, there are a number of other ways. In a sense, there's a sort of the same theme running through a lot of the anomalies. In a sense, it's my Lord Brown's point. Well, why has this been carved out rather than anything else? And as I say, our principal answer to that is that what is being carved out under this particular regime of the Human Rights Act and RIPA is dictated by the subject matter of the legislation, which is complaints by citizens against public authorities, not proceedings by public authorities against the citizen.
But I mean, I know we haven't got an Article 3 case here, but I mean, if we did have, if it was, what's it, Benjamin Hammond or whatever it was, and suing the, trying to sue an intelligence service for Article 3 mistreatment, I mean, you would simply say, well, terribly sorry, you've got to go for the IPT.
If it's in substance a Human Rights Act complaint, your Lordship should perhaps be aware that there are a number of damages claims which have been brought by former detainees in the ordinary courts.
How do they do that?
Because they have studiously, with one exception, they have studiously avoided mentioning the Human Rights Act. They are alleging the existence of a newly to be recognised tort of torture, and they have pleaded their case by reference to conspiracy to injure and false imprisonment, sort of by proxy, so to speak. And those claims are proceeding in the ordinary courts.
And they haven't been challenged on the basis that the substance of the claim is really a claim for
one is partly waiting to see what happens in this case. One is partly waiting to see what... No, at the moment the proceedings, there's no outstanding application to stay the actions and transfer them to the IPT. But I mention that for a number of reasons. One is simply this, that one of the themes that ran through my learned friend Mr. Miller's written case is that this court should not be worried about sending sensitive security cases off to the ordinary courts, because it is said the ordinary courts are well equipped to deal with such issues by means of having special advocates and so on. It is simply the case that this time next week there is a hearing in the High Court in those damages claims on precisely that question, whether or not the High Court does have jurisdiction in a case of that nature to have what may be called, for shorthand, a sort of a closed material procedure, sort of SIAC-type procedure. And liberty and justice are, in fact, intervening to say no. So the...
Well, say no, well, taking the same points as in the control order cases.
Essentially, yes. saying that justice can't be achieved unless the claimants have full sight of everything the court is going to have sight of. So I merely mention that simply to illustrate the fact that consigning cases to the ordinary courts, which involve security issues, is fraught with serious difficulties. And it merely goes to underline the good sense in having set up the IPT. It may also be a jolly good argument for saying, well, it might have been helpful to put even more in the IPT. But it certainly does not encourage an argument for saying that less should go to the IPT, which is what Malone and Friends' argument is. As I say, a number of anomalies have been floated. All of them have roughly the same sort of theme. It's essentially, why this and nothing else? Why Section 7(1)A proceedings? So far as that is concerned, the points that we have made in our printed case at paragraph 39 are essentially three in number. Why Human Rights Act claims, but not other civil claims against the security services. The reasons are three in number. The first is simply, as we have pointed out in our case, that when the Human Rights Act and RIPA were enacted, the overwhelming majority of claims or complaints against the services fell into two categories, which were alleged violations of Article 8, which are assigned to the IPT under Section 65(2)A, and secondly, complaints that the authorisation procedures hadn't been followed under RIPA, which are assigned to the IPT under Section 65(2)B. And so the Act dealt expressly up front with what were then perceived to be the relevant workload. The second point...
I don't quite understand that. I mean, that's going back to Lord Brown's point, is it? That even before 2nd of October 2000, people were seeking to invoke convention rights in judicial review proceedings. Is that the position where you say, at the time they were enacted, the overwhelming majority of challenges involved invocation of convention rights?
Lord, could I take instructions about how sensibly to answer that? Because I was really paraphrasing our case.
Yes, I was just reading your case.
Yeah. Can I...
This one is 6
come back to
39(1).
that? Yes, I understand Lord Cook's question. Can I come back to that after the short adjournment and give you a clear answer? The second point we make is that the Act does not carve out Section 7(1)A proceedings on their own once and forever, and that's our Section 65(2)D point. If in practice it turns out that there is a particular case or a particular category of case that are suitable for allocation to the IPT, then the statute provides an express mechanism for that. And the third reason why it is entirely understandable that Section 7(1) proceedings should be given special treatment in this way is the point I've already made in a slightly different context, which is that claims under Section 7(1) will necessarily require a penetrating examination of the justification for the actions of the services. And there will therefore almost inevitably be a need to scrutinise carefully sensitive material and to evaluate it. And so for that reason, because of the nature of the scrutiny under the Human Rights Act, it is entirely understandable that the Specialist Tribunal, with all the powers it was contemplated to have under Section 69, as we've seen, should have been set up to deal with this category of claim. Another point that is taken against us as a supposed anomaly is that the interpretation which we're urging means that all Human Rights Act claims are allocated to the IPT, even if it is said they are wholly unconnected with the exercise of investigatory functions. And so far as that is concerned, Lord, we have, again, three short answers. The first is that we have already given our reasons for saying that as a matter of interpretation, it is simply not a plausible argument to suggest that 65(2)(a) assigns only claims about the exercise of the investigatory or surveillance functions. So as a matter of interpretation, it is simply not a credible solution to reach. The second point we would make is that it is really, in a sense, the repetition of the one I have just made, which is that because of the nature of the scrutiny under the Human Rights Act, it is entirely understandable why a specialist tribunal should have been established with specialist procedures. And the third point, which ties those two together, is that it is not anomalous for all Human Rights Act claims against the services to be allocated to the IPT, because it is not just in surveillance cases that issues of the public interest, generally the protection of the public interest or of national security in particular, are going to arise. It is always going to be the nature of the evidence that will need to be considered and the nature of the scrutiny that the tribunal will have to conduct that dictate whether or not you need a specialist tribunal, not the nature of the actions which it is sought to impugn. And this case, in a sense, provides a very real illustration of that. Because as I said in answer to a question earlier, one of the points that is being made against us, in a sense I can wrap it up with the next complaint, one of the points that's being made against us here is, oh, well, look, this is a case where you don't have to withhold sensitive information from this claimant because he is a former MI5 officer. This takes it outside the run-of-the-mill of surveillance cases where neither confirming nor denying is a necessary way of protecting the activities of the services. In our submission, that is simply not a good point. And it's for this reason that what is being done within the security service when a manuscript arrives is a collective assessment by the service of whether or not publication would be damaging. Now, obviously, the author knows what he has written, but the author is merely one former officer of MI5. He does not have current knowledge of that which MI5 knows, and even when he was an officer, he did not have perfect vision of everything that MI5 knew. So simply because he doesn't think that what he wants to publish is going to be damaging to the public interest doesn't mean that he is right, and it certainly doesn't mean that he knows everything that needs to be considered in order to assess whether what he is disclosing is in fact a small piece of a jigsaw, the shape of which he is unaware, which is going to make a disclosure which is damaging for reasons he doesn't understand. It's always the vanity of somebody who works in an organisation that they know better. And it is as untrue in relation to the security service as it is in any other. And it is also a matter of comment that when one has left the security service and one is contemplating a publication, presumably for remuneration, it would be beyond human nature to expect that one's enthusiasm to write and publish will be driven as in part by an appreciation of how interesting it will be to the audience. So what we say in relation to this particular case is that you cannot assume that this is a case that when it's decided substantively, when the actual challenge to the refusal is decided, there will be no reason to withhold information from this claimant. There may well be no reason in the event, but that in a sense gives me my next point, which is that the regime under RIPA is not some sort of inflexible, immutable, monolithic procedure incapable of adapting to the circumstances of individual cases. We know, on the facts of this case, that the Security Service has, in fact, in the course of correspondence, already disclosed a significant amount of information to this complainant as to why they don't want particular passages published. So it hardly lies in the mouth of this complainant to say, well, look, there's no power in the IPT to force you to tell me what your case is, because this claimant substantially already knows what our case is. So it's not a real complaint in this case. And the point goes further. It's not just a point on the facts of this case. The point goes further, because under Rule 6.3 of the IPT rules, disclosure can be made by one party to the other with its consent. So if the Security Service takes the view that there are further reasons which haven't yet been disclosed in the course of correspondence, then it can consent to that disclosure being made under Rule 6.3.
I mean, one point against you, of course, is the IPT may say, well, we have no doubt whatever disclosure here could safely be made, but if you choose to say no, that's it.
Well, it isn't necessarily it, my lord.
Why?
Well, because if what is being said against us on the facts of an individual case is that there is further information which is not being disclosed, then it would be beyond imagination that somebody in my learned friend's client's position wouldn't complain that a refusal to provide consent under Section 6.3 is a further breach by the Security Service of the claimant's rights to a fair trial under Article 6. So they would challenge in the IPT a refusal to give consent to disclosure under Rule 6.3 of the rules. So there isn't an absolute blanket power in the Security Service to dictate what goes to the other side. And there certainly is no power in the Security Service to withhold anything from the IPT. And we know, because they do it, we know that one of the procedural measures which the IPT adopts in order to inform itself in relation to material which is not going to a complainant is to have the advantage of advocates to the tribunal appointed. They can also ask for assistance from the commissioners. So there are safeguards in place at two levels. One is actual disclosure of material, that there is the gateway under the rules for actual disclosure to the complainant of material. And the second safeguard is that if there is in fact good reason not to disclose material to the complainant, the IPT can inform itself and therefore reach a more informed view as to the relevance of that material, even if it hasn't been seen by the complainant, by obtaining assistance from the commissioners and or from advocates to the tribunal. And so in those ways, there are a number of elements of flexibility that are built into the regime, which provide appropriate safeguards against the necessary restrictions that are put in place because of the nature of the subject matter. I mean, in answering that question, I have drifted into the final issue, which is essentially ECHR compatibility. I'm not really dealing with anomalies in providing that answer, but I think it draws a number of threads together in explaining why we submit. The complaints that are being made are not real. My Lord, could I just pause and see if there are any other anomalies? Yes, one or two other. Lord, I don't know if now would be a convenient moment.
Yes, certainly. We'll adjourn until 2.